And something that I have a question on is the property transfer tax. Because I understand the property transfer tax is based on the value of the property for the tax slip. But typically, when something like this is done, it's probably an older property. The value in terms of selling value is far from what is on the tax bill. And therefore, to me, if some person was buying it, they probably will pay a lower transfer tax than the person who is inheriting it. So there is a number of questions in there I'm putting to you. First one is why was the deed of gift not touched on?
Well, I would answer that one first, or mention first. We could talk to you guys all day about estate planning and still probably not touch all of the aspects or actions that you could take for estate planning. But as you brought up, yes, transferring via a deed of gift is one of the actions you can take during your lifetime to transfer property as an action of estate planning. So we would have mentioned doing certain transfers during your lifetime, and that is one of them, via that deed of gift, which is a legal document.
Property transfer tax is a real factor. When a deed of gift is actually prepared and transferred, the cost for the property transfer tax, as you mentioned, we look at the land tax value, and that is the value that will be assessed in determining what expenses will be paid in recording that document. When it relates to an estate transfer, a deed of assets, property transfer tax is not payable. So you have to make the choice whether or not, well, it's waived, sorry. You have to make the choice. Deed of assets, property transfer tax is waived, exempt.
A deed of assent is how you would transfer the assets via the will. So you've left a house for your daughter, and to get that property transferred into her name, the legal document is called a deed of assent. So property transfer tax is waived on that document. But on the deed of gift, you've done it during your lifetime and it's payable.
It is payable. What some other persons do is join other relatives onto the title of the property, and I believe when Land Registry and the BRA, Barbados Revenue Authority, calculates the taxes to be paid, they do it on the share that is actually to be transferred, as opposed to the whole sum.
The whole value. So there is in estate planning that you could avoid the full property transfer tax that you mentioned.
Okay, one more question.
Sure.
So if the deed of gift is when the person is alive.
Yes.
Mm-hmm.
So if the person do a deed of gift, but the whole action of it comes about after the person dead, is it still a deed of gift?
What do you mean by the action?
Okay.
It's deed of gift is done during your lifetime.
So he's signed.
So it's signed by you during your
Yes,
lifetime.
yes.
It can't have any action after your death.
It could be recorded because it's signed,
Yes.
and it's a legal document already in place. If it happens to be
So
recorded
what's the
the day
difference
after, it's still
between
going
the
to be
deed of
valid.
assent and the deed of gift then?
Right. The deed of assent does take place after your death. So you've left a
Well,
property.
you would have signed it though, the person
The deed of
who,
assent
No, the deed of assent is signed by that executor.
the executor?
Yes, please.
Not by the person who is giving.
No, because it's after your death.
We'll take 2 more questions.
Hey.
Please stand.
I'm not sure I'm clear on the anticipating marriage that you refer to in preparing the will. Do you mean that if I'm writing a will today in anticipation of marriage, I have a spouse now, we're engaged, and we already set a date?
Yes, you
Yes.
have to have the actual fiance that you have, the person you intend to marry, and you have to write in specifically you intend to marry this particular person. You have to be very specific. It can't be that you plan to marry 10 years from now.
I was wondering.
like somebody
I
that
was
you-
wondering.
Right. The clause is very specific to who you intend to marry. So it's usually for engaged persons.
1 more question, please.
Hi. Yes, please.
If I'm seeking your services to prepare a will, what documentation do I require to bring to you? Do I need bank statements, share certificates, title deeds? Do I need them to bring to you, and what's the approximate cost that you would charge me to prepare such?
We don't need bank statements. When it comes to the actual deeds of ownership of documents, it will be helpful to walk with those so that if there's any joint ownership, we can always verify for you whether or not it's joint tenancy or tenancy in common situation. Any share certificate, it would be helpful to walk with those as well so we can get certain certificate numbers from them. It would be helpful in identifying in your will. And when it comes to cost for members, we charge $195.
And that cost includes having it lodged for safekeeping at the Supreme Court Registry. $195. Right, it's $195, and that includes having it lodged for you at the Supreme Court Registry.
Hi, good night. My question goes back to the power of attorney. You said if the person's mental capacity diminishes or goes at some point in time, then is a guardianship, that a guardian is put in place.
Right,
yeah. You make
So how does that happen, and how is that determined? The mental, well, you mentioned going to the doctor,
Right.
but how is the guardianship put in place?
Right, so the first step is definitely being assessed by a physician, because only then would be able to tell if your mental capacity is diminished enough not to be able to carry on a power of attorney or execute a legal document. So it's an application to the Supreme Court. It's under our Mental Health Act, and it's for a receivership order. So essentially, the court acts as your guardian. You're not able to make decisions for yourself, and the court is going to appoint someone, right, say a family member, the person making the application, as your guardian, and they're going to ask that person to come back periodically to make sure that they're taking care of you and that they're not abusing you because you're not in a state to make certain decisions for yourself.
Great, thank you so
Thank
much.
you so much. Wait, Stacey was pointing at someone.
At what stage on the letters of administration the process would an attorney be required?
From the beginning. From the beginning for any letters of administration process or any application for a grant of probate.
Yeah, they facilitate the application process from the start. So they facilitate the advertisements in the newspaper. They do that. They make the application. They draft the documents. So from the very beginning.
And it's important because there are certain legal requirements for the notices to be placed and certain timelines on when the application could be filed.
Hello. I have a very quick question. If you're still paying a mortgage, are you permitted to make a will of the property in which you're paying the mortgage for?
Yes,
Yes,
please.
definitely.
Thank you.
You're welcome.